Okay, Scott, I should be able to hear you. Are you having, or did you see
Um,
what you needed over there?
Okay, I think so. Can
Good.
you hear me now?
Yep.
Okay, well, we'll go ahead and get started then. Welcome, everybody. As Randy said, um, I wasn't going to be the speaker for this presentation. The slideshow here was put together by Paige Thorson at the Iowa Department on Aging. And fortunately, she had two daughters last week. And so she wasn't able to be with you today. But she has put together this slide presentation, which is just excellent. The only problem with it is it's very long. It has about 48 slides, and we have an hour time to go through them. So what I'm going to be doing is, since you're actually going to get the slides after the presentation, I might be skipping over a lot of the slides that really aren't as relevant to what we want to talk about today. So first of all, just let me tell you kind of who I am. I'm a attorney at Iowa Legal Aid. I manage our legal hotline for older Iowans, and that applies to people who are 60 and over in the state of Iowa. So we deal a lot with people who are not able to make their own decisions. Mostly older people. A lot of them have Alzheimer's or some other dementia. Some of them have mental illnesses. Some of them have brain injuries. So we deal with this quite a bit at the hotline. So hopefully I'll be able to provide the information that you need. This first slide is actually the title slide, Understanding Substitute Decision Making. And if you're like me, I've been working with this since 1997. That phrase, substitute decision making, was always kind of an odd phrase to me, and it took me a couple of years to figure out what are they talking about when they talk about that. Why don't they talk about guardians or powers of attorney? But basically, substitute decision making covers all those areas, and it's basically all it means is that one person is substituting their decision making capability for the person that no longer has decision-making capability, or maybe full decision-making capability. And I think the best way to kind of look at that is that all of us who have children, we are all substitute decision-making people for a while. When you first have your child, you are the complete decision-making person for that child, because she cannot make decisions for herself. But as they grow up, until they reach 18, from a legal standpoint, they do not have the competency to make decisions on their own, even though most of them, when they become teenagers, think that they can make better decisions than we can. So we're all substitute decision makers at one point, and what we're really going to talk about today are people who become substitute decision makers when other people become incapacitated for whatever reason. So today, here's a list of kind of the general types of documents or relationships that people have. We're going to really focus on the first two, the advanced directives for healthcare and guardianships, as opposed to the last three, which pertain more to financial type decisions, because those are a little more easy to figure out than the ones about the guardianship, where you're talking about the personal care decisions that people need to make. And one thing we always talk about in this area is, what are the least restrictive alternatives? Because the thing to remember is, you don't really want to substitute your decision-making ability for another if they can make decisions for themselves. You always want to make sure that the person is allowed to make any decision that they are capable of making, and having somebody else substitute their decision-making abilities for their own is really the last resort. So we always look at the least restrictive alternatives. And then here's just a little slide about the difference between capacity and competency. I think people tend to use them interchangeably, thinking that they mean the same, but they're really two different concepts. Capacity really refers to the ability of the person from a physical, mental standpoint to understand the nature and effects of one's acts. And it really goes to, are they able to understand what is going on? Whereas competency is a legal finding that a court will make, and the judge will look at the person's actual capacity to make decisions, how that affects their functional abilities, their functional limitations, and determine if that person is competent to make decisions for themselves to avoid harming themselves. Okay, this next slide is a, we talked about least restrictive alternatives, and this is really kind of a slide that goes from the least restrictive alternative, which is the person making their own decisions, either by themselves because they're have full capacity and there's no problem with their decision-making capability. To, kind of the next step is, yes, they can make decisions for themselves, but they might need help. And so if all you need is some help to make decisions, you don't need a guardianship. You don't need a power of attorney to make decisions for you. You just need help making those decisions, and more likely is you need help in carrying out those decisions. For example, when my grandmother, when she was 85 years old, I think, she had a stroke, and that did things to her physically, and it also did things to her mentally. But she still had the capacity to make decisions for herself. She had to live in a nursing home at that time. So, she could make decisions about what was happening to her farm, even though she was not able to actually go out on the farm and carry out those decisions. So as long as she had the ability to make decisions, the fact that she needed someone to help her carry them out didn't mean that she needed a guardian to help make decisions. She just needed help carrying out the decisions. So the first bullet point there really goes to, if the person can make their own decisions, either by themselves or with help from others, then that's the preferred and really the required thing that needs to be done. The next one would be advanced directives, and these are powers of attorneys, living wills, both of which are documents that a person signs to actually appoint somebody or tell somebody what's going to happen in the future. The same kind of thing about the physician orders, the do-not-resuscitate orders, or the out-of-hospital do-not-resuscitate orders. Those are things that are prepared by your doctor, but with your consent. And then last of all, the most restrictive would be the guardianship, and that the guardianship is where a court has determined that you are no longer competent to make some or all of the decisions for yourself. Okay, this is a slide about informed consent to make medical decisions. I'm going to skip over that. Basically, you have to be competent to make medical decisions for yourself, and then your consent has to be voluntary after you are told what the procedures are, the benefits, alternatives, and the risks. Okay, this next slide is just a little information on types of services that might be available out there to help you carry out decisions that you make. And again, like I say, the fact that you might need case management or that you might need to live in an assisted living facility or nursing facility doesn't mean you're not competent. It just means you need help with with taking care of what you need to live, but you can make your own decisions about where to live and what type of services you want to receive. Okay, so the first thing that really applies to substitute decision making are advanced directives. These are legal documents. These are, I think, preferred. That really everybody over 18 should have an advanced directive. Usually I'm out talking with elderly people, and lots of times people wait to do advanced directives when they're elderly because they're thinking, oh, something might happen to me in the future that I can't make decisions. But really, anybody over 18 should have an advanced directive, at least the durable power of attorney for healthcare. What the power of attorney is it allows you to appoint somebody to make decisions for you for healthcare issues if you're not able to make them for yourselves. And the reason everybody should do that is, especially folks, that are working with people with brain injuries is a perfect example. I always tell people, your grandson at 22 can go out, be in a car accident, and could be in a coma for 20 years. And his parents really don't have the legal authority to make decisions for the 22-year-old anymore because he's an adult. So unless he has set up a power of attorney, more than likely the parents or whoever's helping him is going to have to go to court, set up a guardianship, and then the guardian would make decisions for that person. So the preferred method is to do a little planning ahead of time and do the power of attorney so that if something happens to you that you cannot make decisions, that can be taken care of without the expense and time and hassle of going to court for a guardianship. So there are basically two types of advanced directives that we'll focus on today. One's the durable power of attorney for healthcare, the other is a living will. We recommend that everybody have a durable power of attorney for healthcare, and that the living will is more of a philosophical, religious decision about whether you want to do that kind of document. So the power of attorney for healthcare is the most important one, and like I say, it allows you to appoint somebody to make decisions on your behalf. Under the power of attorney, the person you appoint, your agent, is supposed to make decisions according to your wishes. So when you appoint somebody a power of attorney, it's a good idea to first ask them whether they want to be appointed, because they may not want the responsibility of making decisions for you. But if they do, it's a good idea to sit down and talk with them kind of generally about what types of decisions you would make under various scenarios. And there are lots of things on the web out there. There's a booklet called Gift of Peace of Mind. There are lots of things like that are good documents. I sometimes tell people, though, don't get bogged down in those documents because sometimes they're very complicated. Sometimes they want you to think of every type of decision that might need to be made in the future. Whether you have a stroke, whether you have a brain injury, whether you have a heart attack, anything in the future, and you're expected to say now, even though the document might not need to be used for 20 years, what you would want to happen if you had a stroke or if you had dementia. And although I think it's good to go through that exercise, I think sometimes people get bogged down in thinking about that, and so a year later they still haven't executed a document. So what I usually recommend to people is do a healthcare power of attorney. Just use the simple statutory form that allows you to appoint somebody to make decisions for you, so that if something does happen next week, you have somebody there to make those decisions. And then if you want to take a year to kind of go through all these various scenarios of what could happen in the future, you can always make a new power of attorney next year with all your wishes in it. But and the other thing is, it's hard to know. You know, what do you know, how are you really supposed to know at age 50 what you might want to happen when you're 85 and you're starting to get dementia? It's hard to know that. So so even though you might not know that for sure, it is good to talk with the person you appoint so they have some indication of what your desires are. Because if they don't know your desires, then what they have to do is act in your best interest. And what that means is they have to make a decision as to what is in your best interest. Whereas if they know that, for example, if you told them, I always want to be hooked up to life-sustaining equipment, just in case a miracle happens or some great medical discovery is made, so keep me alive as long as possible. If you don't tell them that, then they don't know that. And so then they're going to make their own decision based on their own philosophies and thinking about what they think is in your best interest. But if you haven't discussed that with them, then that's what they're supposed to do, is look at your best interest. The other important aspect of a healthcare power of attorney is it does have priority over a guardianship. So if you've done a healthcare power of attorney, appointing your daughter as your agent for healthcare decisions, and then 20 years later something happens to you and your son goes and applies for a guardianship, becomes your guardian, your daughter is still the person that has the decision making, the legal right to make decisions for you, even though the guardian has been appointed and would make those decisions if you hadn't had a healthcare power of attorney. This is a slide just kind of defines some various decisions related to healthcare powers of attorney. This is a slide about the process of making a healthcare power of attorney, so you can read those by yourself. This is a slide about the responsibilities of the person you appoint. And again, we've kind of already gone over this. They're supposed to act according to your desires, and if they don't know that, then act in your best interest. Revoking a power of attorney. Healthcare powers of attorney are kind of interesting. To actually execute a power of attorney, you have to be competent at the time that you sign it. But for revoking it, the Iowa Code specifically says that you're presumed to be competent if you revoke it, which I always thought was kind of strange, because I advise people to do these documents so that they don't have to go through a guardianship proceeding. But if you're laying there in the hospital in the bed and everybody in the world thinks you are not competent, if the doctor asks you, well, do you want your daughter making these decisions for you? You've got a power of attorney here saying you do. All you have to do is tell the doctor, no, I don't want her making decisions for me. And that's going to revoke the power of attorney. So you're right back into it's just like you've never done the power of attorney. So then somebody's going to have to probably get a guardianship to make the healthcare decisions for you. And the one thing this third bullet point, I think, is a little misleading. It's accurate, but it's a little misleading. It says it terminates upon disability or incapacity unless it is a durable power. And what a durable power means is if there's language in there that specifically says it continues after you become disabled. And the reason I think this is a little misleading is because all of the documents about that, all the forms for healthcare powers of attorney are durable. So you don't need to worry about that. And I guess the other thing to know about powers of attorney is they only take effect, or they only go into effect when you do become disabled. As long as you're able to make decisions for yourself about healthcare decisions, then the person you appoint has no ability to make those decisions. Now, that's one issue it raises that I get quite a bit on our legal hotline. I'll be talking to somebody and she'll say, well, I don't want to do a healthcare power of attorney because the only person I would appoint would be my son, and as soon as I did that, he'd throw me in the nursing home. Well, putting you in a nursing home is a function of an agent under a healthcare power of attorney, but until you are not able to make that decision for yourself, he would have no authority to make that decision for you. Uh-oh. Something just happened here, and I have lost access to it. There it goes. Okay. 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 So a little bit here, we'll talk about final disposition documents, although they're not real relevant today. These are new documents that were authorized by the Iowa legislature, probably 3 or 4 years ago. And this is a document that you sign to appoint somebody to make decisions after you die. Because one thing about normal powers of attorney is they end the second you die, whether it's a healthcare power of attorney or a financial power of attorney, they end the second you die. The person you appointed has no ability to make decisions for you. So this new document allows you to name somebody to make decisions about what type of funeral to have, whether to be cremated, what the services are going to be like, where you're going to be buried, things like that. And this was needed a lot because of the fact that we have a lot of what we call blended families anymore. So, your mother dies, and your father had died 10 years ago, and she got remarried, and now when your mother dies, the question is, do you have the authority to make decisions about her funeral and burial, or does that new man she married have those decisions? So this new law clears this up, and if your mother signs one of these documents saying that her new husband makes decisions, then he has the authority to make decisions. If she signs a document saying a child has those decisions, then the child has it. The other good thing about the statute is if you do not sign one of these declarations, then it sets up a priority about who does get to make those decisions. And the spouse is always the first order of priority. So even if she'd been married to your father for 50 years and just married this new guy 6 months ago, if she dies without having done a declaration, then the new husband decides her funeral arrangements. Okay, living will. That's generally the other type of health care directive that we talk about. And this is a declaration that informs your medical personnel whether or not you want to have life-sustaining procedures taken, either withheld, withdrawn, or it can do just the opposite too. It could say, I always want life-sustaining procedures. And please don't withdraw them, just to make that clear. And living wills, they only apply, they're very limited. It only applies if you have a terminal condition. So, if you are out in a car accident, even if you've done a living will that says, I never want to be hooked up for life-sustaining equipment, the medical personnel, they're going to hook you up to whatever's needed to keep you alive, because in a car accident, normally you don't have a terminal condition. You might be hooked up to machines for a month, but after that month, you're going to get well and return to having a normal life. So it only applies in a terminal condition. So like if somebody has, say, end-stage renal cancer, and the doctor says, well, we can keep you in the hospital hooked up to machines, and you might live another 2 months, or we can not hook you up, and there's a good likelihood you'll pass away within a week or so. In that situation, you have a terminal condition, and if you are not hooked up to life-sustaining procedures, then you're going to pass away. So that's when the living will goes into effect, or has an effect. So then the rest of these slides are just some general information about life-sustaining equipment, what's a terminal condition, how to make a living will, and revoking a living will. And again, the good thing about this law, the living will law, is if you do not have a living will, then it sets up a priority of people again that can make that decision for you. And the first person, again, is the person you've designated as your healthcare power of attorney. And then if you haven't done that, if there is a guardian, the guardian has the decision-making authority, and then it goes to your spouse and some other relatives. And that's our family consent law. Okay, now we're not going to talk any about these DNR orders and stuff like that. Instead, we're going to go to talk about guardianship. So what is a guardianship? Well, guardianship is where you go to court and the court appoints somebody to be the guardian to assume the responsibility for the physical custody of another. So you have the guardian, and then the person who is not considered able to make decisions for themselves is called the ward. There are various types of guardianships. It used to be that when people got guardianships, it was just always a full guardianship, and the guardian was in charge from then on. There was a case that Iowa Legal Aid did called the Hedin case, which, boy, it's getting old. It's probably 10, 15 years old now. And what the Hedin case said is, no, we shouldn't assume that people always need a general or full guardianship. Instead, the court has the responsibility to determine, does the person have any decision-making capability? And if they do, then they should be allowed to make the decisions that they are able to make. And then the decisions that they're not able to make, those are the decisions that are to be given to the guardian. And so, you know, really most guardianships should be fairly limited. And although that was the decision of the Iowa Supreme Court, I think judges are still kind of inclined to grant full guardianships because it's just kind of more complicated to go through the process of determining what the ward can and cannot do. So unfortunately, I think there are probably a lot more general guardianships than there should be today. So here's a Hedin case, the Iowa Code provision. And like I said, the court is supposed to determine how much help the person needs and rule out any less restrictive alternatives before doing a complete full guardianship. And at the bottom of this slide, there's the standard. A person whose decision-making capacity is so impaired that the person is unable to care for the person's personal safety or to attend to or provide for necessities, without which injury or illness might occur. So you know that definition talks about capacity. So the judge is supposed to look at the capacity of the person to make decisions. But then just because they have impaired capacity does not mean that guardianship is needed. Instead, the judge has to find that the diminished capacity of the person is such that it's going to affect their ability to remain safe and secure. And if it isn't, if they just have a little impaired capacity, then there's really no reason for a guardianship because they can take care of themselves without incurring any harm. This slide basically shows you the powers of a guardian without court order. The specific codes sections split them into, these are the powers that guardians can exercise. The general ones, providing care, comfort, maintenance for the ward, take care of their clothing, furniture, etc. And basically try to do things that maximize the person's independence. And there are other powers that the guardian can exercise only if they get a court order, and those include changing the ward's permanent residence if the new residence is more restrictive. So if you've got a ward who happens to be able to live at home and then maybe gets worse and needs assisted living or nursing home care, before going to those more restrictive residences, the guardian would have to go to court and show the judge that the ward actually needs a more restrictive living environment. They also have to get a court approval for major elective or non-emergency surgery, or to consent to a do-not-resuscitate order. So again, without, sometimes guardians get appointed and they think that they can do anything they want on behalf of the ward. But really, guardians only have the powers that are authorized by the court or are otherwise listed in the Iowa probate code, which is where the guardianship law is. And there are some things that a guardian can't do, and here's a list of them. So voting. A ward is entitled to vote unless they're found in a separate proceeding to have unsound mind, then they can't vote. They also have the right to marry, and the guardian can't decide, no, you can't get married to this person, or yes, you do have to get married to this person. So the ward can marry unless the ward lacks capacity to contract a valid marriage. Wills, the guardian cannot make a will for a ward, so it all depends on if the ward has the capacity to understand and execute a will, like everybody else. And then visitation. The ward has the right to determine who's going to visit them unless that decision might be harmful to them. So what happens if a ward, well, when does the guardianship terminate? Well, one is if you're a minor, the ward, well, you normally don't need a guardianship for a minor because the parent is the natural guardian without going to court. But let's say there aren't any parents, or they're not around, and somebody else becomes the guardian for a minor. They become the guardian not because the minor has any lack of physical or mental capacity. It's more a legal determination that minors do not have the capacity to make decisions for themselves. So if a guardianship is appointed for a minor, when they reach 18, that guardianship is going to terminate, and if the guardian thinks it should continue, they're going to have to go to court to show not just that the person is a minor, but that the person does not have the capacity and competency to make decisions for themselves. They also terminate the death of the ward if the court determines that the person no longer needs or that their decision-making capacity is no longer impaired, or that it's not necessary for some other reason. Okay, so one thing I want to talk about on this is, just briefly about, kind of the difference between powers of attorney and guardians. So kind of the first thing to know is you may not have a choice on which avenue you go to, because to do the power of attorney, the person must be competent. So, talking about people who sustain a brain injury, that might in itself make the decision for you. Because if after the brain injury, the person is no longer competent to make decisions for themselves, and they have not executed a power of attorney before the accident or whatever caused the brain injury, then the power of attorney really isn't an option anymore. Instead, you would have to go to court and get a guardianship set up. That's similar to elderly people. If somebody has Alzheimer's and they fail to do a power of attorney before the point in time where they have become incompetent and are unable to make a power of attorney, then they have to go to court and get the guardianship set up. So the better thing to do is think about this ahead of time and before you need somebody to make a decision for you, and decide then, do you want to have a person making a decision based on a power of attorney, or do you want to have it based on a guardianship? Powers of attorneys, the thing about them are they're simpler, they're not less complicated. You don't have to go to court to get it set up. You don't have to file an annual report every year. You don't have to get the court's approval of your actions during the year. So if somebody does a power of attorney, that person they appoint can basically make decisions for them in a simple and very non-complicated manner. On the other hand, those same factors might be the reason why you don't want to do a power of attorney. Because if you only doing a power of attorney, there are no annual reports that a court has to look at. There's no court supervision to make sure that the person you appointed is doing what they are supposed to do. And so kind of the only oversight you might have is if you or somebody who is kind of looking after you in an informal manner thinks that the person you appointed is not doing what they should be doing. And then it would be possible to either revoke the power of attorney or go to court and have a judge declare that your agent is no longer your agent. So, some people, they don't have relatives, they don't have friends, they don't have anybody they trust. So, in those situations, you don't do a power of attorney because there's no one there to appoint. And so you just kind of leave it up to others. And if something happens to you, if you don't have somebody that's going to say, oh, Sally needs help, and so maybe we should set up a guardianship. As a final resort, it can be reported to the Department of Human Services, and the Human Services can determine that you need a guardian or a conservator appointed to help you. So, kind of the bottom line is for those people that have somebody they trust to make decisions for them if they're not able to, it's usually better to go the power of attorney route just because it's a simpler process. But sometimes it's actually safer to go the guardianship conservator route so that people actually do have somebody that they have to report things to. And for people that have a guardian or a conservator, lots of people, they have them and they don't like what they're doing. They don't like the decisions they're making for them. And so in that case, you don't have to just live with the decisions the guardian is making to you. You can go back to court. You can ask the court to terminate the guardianship. And to do that, you would basically have to convince the court that you do now have a decision-making capacity and you don't need a guardian anymore. Or if that's not true, if you still need a guardian, you can tell the court, okay, I have a guardian, but they're not making good decisions. Or maybe they're using my money for their own purposes. And they're not taking care of me the way I should be taken care of. So you can go to court and convince the judge that, okay, you might still need a guardian to make decisions for you, but you would like somebody else to be the guardian. And that's done quite often. Okay, so the rest of the PowerPoint is really directed at financial management decisions. And again, here's a kind of a listing of various things from least restrictive, meaning you direct your own financial decisions, to the most restrictive, which is somebody has set up a conservatorship to make financial decisions for you. It's just a little information on money management programs. Representative Payee, those are programs by Social Security, the Veterans Affairs, and other federal agencies who, if Social Security gets information that you maybe are not handling your retirement benefits or your SSI benefits properly, they will appoint somebody as a representative payee. They're not a conservator, they're not a guardian, but they only have authority over your federal payment. And they have to file reports every year with Social Security Administration about how your money was spent. So they're supposed to use that money to pay your bills and then give you so much so that you can handle your own personal needs. Durable power of attorney for financial decisions. That's just like the healthcare one. The thing that's different about it is in healthcare powers of attorney, they really only go into effect at the time you are not able to make decisions for yourself. For the financial decision power of attorney, you can do that, you can have it the same way, or you could make it effective right now. So you could appoint somebody, you need somebody to help you, pay your bills and deal with your finances. You can do an immediate financial power of attorney so that they have access to your bank account and other financial accounts, and you would still have access, so you can still spend money out of them, but they have authority to do those things for you also. And that's just what we just talked about there. And then again, if you become incapacitated and cannot handle your financial affairs anymore, if you have not done a power of attorney for financial affairs, then somebody's going to have to set up a conservatorship, and the conservator is the person who takes care of your financial affairs for you. And unlike the healthcare decisions, if you've done a power of attorney for financial matters and then a conservatorship is appointed, the power of attorney authority ends. So they have no more authority to handle your finances once a conservator is appointed. Whereas the healthcare power of attorney continues to have authority over healthcare decisions, even though a guardian is appointed. And these are just the various types of conservatorships. Here's about when they terminate, which is similar to the guardianships. And here is Paige's contact information. So she's not going to be back for about, well, she's planning to be back in August, but who knows? With twins, she may be out longer. But feel free to call her up if you have any questions about these issues, or you can also contact me or one of the other attorneys at our legal hotline for older Iowans. I'll just give you that number since we don't have it on here. It's an 800 number, applies to all of Iowa, so it's 800 992 8161. Again, that's 800 992 8161. So you can call that number if you're 60 or over. If you're under 60, you can call our regular Iowa Legal Aid number, and that is 800 532 1275. So 800 532 1275. I'm not, that doesn't sound right. At 532, that's Paige's number here. Oh, well, well, you probably know what Iowa legal aid's number is. So I guess that's about, we went through those slides quicker than I thought. So we have about 15 minutes left. So Brandy, do we have any questions
We do have a couple of
from people?
questions. Um, the first
Okay.
question, I'll just read it here. What if a couple has their spouse, basically one of the spouses, as their power of attorney, and then they get divorced, and the power of attorney is forgotten, and something happens, and the power of attorney doesn't want the responsibility at that point after the power of attorney is needed?
Okay. Well, there's actually a couple questions there. And the first one, I have to admit, I'm kind of guessing on this, but I think I'm correct. I believe that if you appoint your spouse your power of attorney, I believe the power of attorney ends when you get a divorce. And I'm pretty sure that's true, because it's true with other types of things. So like if you do a will saying your spouse gets all your stuff when you pass away, and then you get a divorce, then as soon as you get the divorce, that will is no good, according to the
I think that's helpful,
as
and
far
that's
as
certainly something that
finances.
people could probably check into further for more details. Is that something you think they maybe direct that to Paige, do you think, to get more details?
Yeah. The other thing the other question that raises is, uh, you said, well, the spouse doesn't want to do that anymore. Well, that's true with any power of attorney. So when you appoint somebody either for healthcare or financial decisions, that's why it's so important to talk to them when you do it. Because if you if you don't talk to them, or even if you do talk to them and say, yeah, oh yeah, I'll do that, 20 years later, when you need them to actually make a decision for you, there's nothing that requires that person to make decisions for you. So they can just decide on their own at that time, oh, sorry, I'm too busy. I can't handle those kind of decisions. I'm not going to do it. And so it's just like, it's just like you didn't have a power of attorney. And so in that situation, assuming you're incompetent, then somebody would have to go set up a guardianship or conservatorship. So so you need to be sure that the person you appoint wants to make those decisions for you. And it's probably a good idea to talk to them every couple of years and say, now remember I appointed you to make these decisions. You're still okay with that, right? Um, and hopefully they'll say yes and everything will be fine. But there's no way you can force them to make decisions for you if they don't want to at that time.
Great. There's another question here. How does someone terminate financial power of attorney? And then they go on to say that there's an elderly gentleman who has designated his kids has to have financial power of attorney and now wishes that he hadn't done that. How does he revoke it?
All you need to do is just send a letter to the person that you appointed saying you're revoking the power of attorney. And it'd be nice to kind of make it clear, I'm revoking the power of attorney that I signed on such and such a date. Um, but if, for some reason you don't have a copy and you don't remember when it was signed, it's perfectly legal just to tell them any power of attorney I've given to you is no longer valid. And so that's supposed to prevent them from acting on the power of attorney anymore. And once you've done that, if they do act on the power of attorney, they would be liable for anything. So if they went down to the bank and emptied out your account after you revoked the power of attorney, they would be liable to you for getting that money back. But because there's nothing recorded or anything, if that does happen, the good thing to do is notify the bank where your bank account is or the stockbroker where your stocks are. And because you probably gave them a copy of the power of attorney when you set it up. And if you didn't, the person you appointed probably did. So you just, contact the bank, show them the letter you wrote to the power of attorney saying you revoke it, and tell the bank don't honor that power of attorney anymore. That way, if the person you appointed does come down a week later and try to empty out your account, the bank should not be doing that because they know about it at that point.
Great. Next question indicates that there is a couple of individuals in a facility that this is from someone who works at a facility, saying that there's a couple of individuals in their facility who do not have family members or interested parties to make decisions on their behalf. So, what agencies are available for them to get a guardian appointed and to make healthcare financial decisions for them? I'll stop there. There is a second part to that question, but I'll let you address sort of that one first.
Yeah, that's that's uh, that's one of our big problems here in Iowa. Iowa does not have a what's called a public guardianship or a public conservator. Most states do. So in most states, if you have no family, no friends, nobody willing to be your guardian, there is some agency out there that you can go to and say, hey, I need somebody to take care of my things. Iowa doesn't have that. We started to have it 4 or 5 years ago, and state funded it for a year or so, and then it revoked the funding, and so it's really a problem here in Iowa, and it kind of depends on where you are now. Here in Polk County, there's a Polk County Attorney's Office has a volunteer people that act as volunteer guardians or conservators for people, but most counties don't have things like that. So, if it really comes down to it, you report it to Department of Human Services. There's an adult abuse agency, and abuse for the Iowa adult abuse law includes self neglect. And so if you're not able to take care of your things anymore, DHS should investigate that, find out that it's true, and then they can go through the process of they refer it to the county attorney, who will then set up a guardian or conservatorship for you, whatever you need. But that's really just kind of a last resort, and I become frustrated with DHS because lots of I think they normally help people who are still living at home but aren't really able to do that anymore. But once people get in nursing homes, they say, well, they're being taken care of. The nursing home's taking care of them, so there's really nothing for us to do. So then it's kind of a problem for the nursing home if either they're not getting paid or there's not somebody to make decisions for that person. So, in the end, the nursing home could file a petition in court saying this person is not able to make decisions for themselves anymore, and the guardian or conservator should be appointed to make those decisions. And then it's a question of just finding somebody to be that guardian or conservator.
So in that instance, I'll go ahead and read the second part of that question. Um, Basically, it's what happens if the individual doesn't have funds to pay for a guardianship to be appointed, court fees, that sort of thing. So then does the state just pay for that?
Yeah.
Okay.
Yeah. If there's no estate there, then it comes out of county money, I think.
Gotcha. Okay. Um, uh, a suggestion here from one of our colleagues that has offered a little bit of information. Basically, the local area agency on aging, or Iowa Compass, does have a list of paid providers for guardianship services, people that do that. So thank you, Mike, for offering that.
Great. That sounds like Waterloo, maybe?
Sorry?
That sounds like that might be in Waterloo.
University of Iowa, I think, is where they're out of. Iowa Compass.
Okay, okay,
Yep.
yeah, Compasses.
Yep. I know there was one question that we had here on our end from one of our facilitators in regards to representative payee through Social Security. I don't know if that's something that if you can answer or not, but the question was specifically if an individual who is getting Social Security disability benefits can actually request from Social Security to have a representative payee put in place and request it be someone if they don't already have that in place. Can they request that, or does it have to be a decision made through Social Security?
Well, it's a decision made by Social Security, but I'm pretty sure that a person can contact Social Security and say, hey, I can't handle financial decisions anymore. Can you appoint somebody for me? And then Social Security makes the decision that somebody
Okay.
needs to be appointed.
Okay. And then one more addition here, which very helpful, thank you very much, is that DHS is they cannot actually go into nursing homes to do investigations. That DIA actually is the governing body that would be the one to contact if the individual is in a nursing home during that time. So thank you, Terry, for offering that information up. And that counties only can pay for the guardianships if it's already in their county plan to do that. So you'd have to defer back to the county to find out if they already have it in their plan to pay for that or not. So that is good to know. Another question here, is the conservator specifically one person, or could it be, for example, the nursing home itself?
Ah, there are some restrictions on nursing homes, like a nursing home can't be a trustee for one of their patients, and nursing home could not be appointed a healthcare power of attorney. But I don't know if there's any restriction about them being a conservator. I just not don't know that answer. Okay, any more questions, Brandy?
I had muted myself again. Sorry, I'm unmuted now. Next question is if there's an ombudsman in Iowa that covers nursing homes. Um, is that something you
Yeah,
want to
Iowa
speak
has
to? Okay,
Iowa has a long-term care ombudsman's office. It's run out of the Iowa Department of Elder Affairs, and they have, oh, I think they're up to like 8 or 9 ombudsmans now. So if people are having a a problem with a nursing home as far as quality of care or specific rights being violated, they can contact the ombudsman's office, and they're usually pretty good at working with the nursing homes to get situations resolved.
great. Next question is in regards to a couple that gets divorced and one of the spouses was guardian, as opposed to the previous question where I believe it was referring to power of attorney. Do they still go through the court, or does the divorce finalize the guardianship as well as it would with the power of attorney?
Yeah, I don't think a divorce automatically terminates the guardianship. I know it doesn't terminate the guardianship, but I don't even think it ends the specific guardian. Um, so I would think what would happen is if you're filing for a divorce from somebody, you would at the same time go into the probate court and ask the judge to appoint somebody else as the guardian. But
Okay,
normally you wouldn't want your ex-spouse to be your guardian.
thank you.
But it doesn't happen automatically, I don't believe.
Okay. Next one here is we've had individuals request that the facility or a specific individual help them with finances. And oh, okay, gotcha. That indicating that um, that Social Security has always approved a specific individuals or a facility assisting with finances. So just offering that up to the issue surrounding representative payee.
Oh, yeah,
Um,
yeah. Nursing homes can be representative payees.
so, and that looks to be all of the questions. I don't see that anybody else has typed any in here. So I really want to thank everybody for attending today, and I will be sending out the all of the information that I mentioned above. I did have one individual ask in regards to, they've had people sit and watch this presentation together in an organization. So if you have kind of bunked up in one office to do that today on one computer, if you want to just email me with names and email addresses of the folks that participated in that today, then I can make sure and get certificates of attendance to everybody, because obviously it's only going to show the people that logged on. So any other questions that people have, feel free to email me, and my email address is on the GoToWebinar stuff that you've been receiving. So thank you so much, and we'll go ahead and close out.